Hi everyone, my name is Gabriela Urizar and I'm an immigration attorney at Manifest Law. I have almost a decade of experience advising multinational corporations, some of the largest employers in the US, and also, of course, foreign nationals who want to come to the US and utilize their credentials, their career, their professional history to start a life here in the United States. Today, we're going to be answering some questions that were previously submitted by our viewers, but we're also opening the floor for people who have questions right now. I understand that there have been a lot of breaking news announcements in relations to immigration, so everybody needs some updates. But let's start with the first question. Great. This is a really good question that keeps coming up, especially for people who are monitoring information about the new Trump Gold Card that was announced. I believe it was last week. But I'm also going to post a link in the chat of a resource that Manifest created where we really break down the difference between the EB1, the EB5 versus the Trump Gold Card. But I'll speak about it. Let me just posted. Okay, I'm gonna send it to my team so they can post it. But this is a great article that was done by the attorneys here at Manifest, where it breaks down the difference between the EB5 and the Trump card. But for example, let's talk with the overall guidance, right? So the Trump card visa and the EB-5 immigrant investor program provides a pathway to lawful permanent residency status based on financial contribution. So that's the thing that they have in common, but they have different investment requirements. So for example, in terms of the minimum financial amount that you need to contribute in order to qualify, under the Trump Gold Card visa, individuals applying for this visa will need to pay $1 million per head, meaning that if you're applying for yourself, you need to pay $1 million. If you're applying for your children or a spouse, you need to pay $1 million per person. If an employer is sponsoring someone under the Trump Gold Card, they will need to pay $2 million per employee. Now, let's compare that with the EB-5 investor program. The EB-5 requires an investment of about $800,000 if you're going to be investing in a targeted employment area, for example, an underserved area, like an area that needs economic development, or a little bit over $1 million if you're invested in a non-targeted employment area. Another difference is the financial structure. For the Trump Gold Card visa, it's a non-refundable gift to the US Treasury. For the EB-5, it's an investment in a commercial enterprise. So you are able to invest this money and continue to produce and get gains from this money. The Trump card is different because it's a gift to the US Treasury, so you will not be seeing this money. Now, job creation requirement. The Trump Gold Card has none. It doesn't require you to show that you are creating jobs or that you are continuing to maintain the investment. However, the EB-5 card or the EB-5 program does require that you have to show that you will be creating and maintaining at least 10 full-time jobs. Now let's talk about the legal foundation between the two. The executive order that just passed last week, a few months ago, where it was announcing the gold card, shows that it could possibly be reversed by a future administration. I mean, we've seen this with prior administrations where they've issued executive orders, and then the new administration comes in and is able to reverse that executive order. The legal foundation for the EB-5 was created by an act of Congress in 1990. Another key difference between these two as well is the visa category. From the very limited guidance that we received from the government, it appears that people applying for the Trump Gold Card will fall under the EB-1 or EB-2 category, right? The EB-5 will fall under EB-5 category. You need to remember that only Congress can create visa availability or increase the cap per category. So a lot of questions that are surrounding this new gold card is whether this card will create a further backlog for categories EB-1 and EB-2, since that's where it will be applying for. Okay. How early or late can an H-1B petition be filed? Can someone earning 100,000 apply for the H-1B? So it is important to break down this even further because the process is different. So, for example, if you already have an H-1B petition and you're planning to file an extension, the earliest that you can file an extension is 6 months prior to the expiration of your current H-1B. If you're filing an amendment or a change of employer, you can file it as soon as the change happens. Now, in terms of a new cap, right? Let's say you never had an H-1B, you're a student, or you're under another work visa, but you're interested in the H-1B. The first step is that your employer will need to register your name in the lottery. And this usually happens around March. Then USCIS will do a random selection of the people that get selected under the lottery and then invite them to apply for an H-1B petition. The H-1B petition most of the time include a start date of October 1st, right? If your start date is even further away, the employer can think about putting that date on the form I-129, but usually October 1st. So once you file the application, usually people have until June, July to file the application for the H-1B, and then the start date will likely be October 1st. Now, let's keep in mind the processing times with USCIS right now, which are very delayed. A lot of people wonder, hey, like filing 6 months ahead of time prior to my expiration is not long enough because USCIS is taking over 6 months to provide an answer on petition. So what would happen to me if I file a petition, but it takes longer than 6 months and then my current H-1B expires? Am I out of status? That is a very common question that people have. Usually it depends, right? If you are in the US and you don't leave the US while your petition is pending, you can file for the extension prior to your expiration. And if by the time your current status expires, USCIS has not given you an answer, you can rely on the rule called the 240-day rule. As long as you don't depart the US, you can continue to stay, live, and work in the US until you either max out of your H-1B time, USCIS provides a response, or you run out of 240 days. So whichever is shorter. So you have to remember that. So for example, if you only have 6 months on your H-1B before you max out, you wouldn't really be able to enjoy the full 240 days, right? So just keep that in mind. Very important. You speak to an attorney if you file a petition and you're thinking of traveling on or departing the US. Now, for the second part of the question, can someone earning $100,000 apply for an H-1B? It all depends on the wage level. When you file for an H-1B application, you are required to file for an LCA. So the LCA is a document that you will file with the Department of Labor, and you will include the wage level, the credentials that are necessary for the job, the type of education, the years of experience, and then the Department of Labor will provide you with the minimum wage that you must be paid based on all of these credentials and also based on the area where you're currently working. You must be paid by your employer the wage that's listed on the LCA or above. And this is done so that the US can protect the labor market and they can protect US employees so that, for example, employers are not hiring foreign talent so that they can pay them less than what they're supposed to be paying a US worker. So it depends, right? If your job requires a salary less than 100K, totally, you can apply for an H-1B. But if the LCA comes back higher, your employer has to pay you at least that wage or higher. Okay, let's take another question. I heard that the US banned Nigeria from immigration, and it will likely take effect on the 1st of January 2026. How true is this? If I file my EB-1A petition this year, will the ban affect me? This breaking news just came out yesterday, last evening. So Manifest was able to jump on it really fast, and we created a guidance and information about this travel ban and how it applies to people, because it's two categories: the partial travel ban and the full travel ban. And every category lists different countries. So we're going to post the link in the chat so that you can read that with more detail. But basically, the U.S. The president came up yesterday and issued an updated travel ban. There was already a travel ban, which included a few countries like Venezuela and Cuba, but this new travel ban from yesterday expanded the categories of the partial travel ban and the full travel ban. Okay, so yes, Nigeria was included. Let me just take a super quick look to see under which category was Nigeria included. This is many countries, and then I'll explain what can you do in your situation. Okay. So Nigeria was included under the partial travel ban. Again, make sure that you check out this document, because it provides you with more information. If you are inside of the US, this travel ban likely will not affect you because you're already in the US, right? But if you're planning to leave or depart, you have to take a look at the type of visas that the US is banning for Nigeria, because it's a partial travel ban. So it's not all of the visas, right? And also keep in mind that there could be some exceptions, and the US always, most of the time, make exceptions, especially for people that are married to US citizens. So please make sure you consult with an immigration attorney before you try to depart the United States, especially since you were born in Nigeria. But if you're inside the United States, you're likely okay with filing your EB-1A. Okay, the next question. I saw that Trump card is available and applications can start. Do you know what the process will be like and how long will it take? So just a brief reminder for everyone, this is a very new type of visa. The guidance and the information that the Department of State and the USCIS have provided is very limited. They haven't really processed a full visa, so we don't know how they're gonna process it, how long they're going to take. But yes, it is available at the portal. And also we created a guide about this type of application and any information that you need to know if you're considering applying for the Trump card. A reminder, this is a very new and complex type of visa, so there is highly recommended that you speak to an immigration attorney before you file this application, especially since the processing fee of $15,000 per application and the $1 million gift is non-refundable. You don't want to lose that money. So we're going to post it here in the link. More information. Yes, you can put your information on the website that the administration provided. If you're interested, they will do a vetting and then they will allow you to apply for the application. Let's see the next question. I currently hold a valid H-1B visa stamp that is valid for another 3 to 4 months and had received a new approved Form I-797 last year. Amendment is valid until October 2027. I'm guessing your question is if you can travel using these documents. Okay, is it necessary to obtain a new H-1B visa stamp solely because the approval notice has changed, even though the existing visa stamp remains valid at the same time of re-entry to enter the US? If you have a current visa stamp sticker on your passport that matches the category to your new approval, you don't need to get a new visa stamp. You can continue to use your old visa stamp, which is still valid, with your new approval notice. Just make sure that you carry both when you try to re-enter the country. If I move from a TN visa to an H-1B, what does the process look like? I think it depends whether you are a Canadian national or a Mexican national. If you are a Mexican national and you're already living in the United States under the TN, you can always file a change of status with USCIS with Form I-129 to transfer to the H-1B, assuming you got selected for the H-1B and you are able to apply. The H-1B does carry more flexibility than the TN because it's a dual intent visa, and you can actually pursue at the same time an application for permanent residency. Now, if you are a Canadian national and you want to apply for the H-1B, the process will be very similar. Just keep in mind that for Canadian nationals, usually you don't need a visa stamp. I recommend, again, to speak to an immigration attorney to show that the facts of the case so that they can provide you with a more tailored approach. But if you're usually inside the United States, you apply with USCIS, you get your approval, you make an appointment at a U.S. consulate or embassy to get the visa stamp, the sticker on your passport, so that you can travel out and come back into the U.S. with your new visa stamp. You don't need to get a visa stamp unless you're planning to travel. There's plenty of clients that don't want to travel. They just want to file the change of status here in the U.S., and they don't really have to get a visa stamp because they're not planning to leave the U.S. and then re-enter. If an H-1B employee receives a 221G administrative processing notice during a visa interview and their employer allows them to work outside of the U.S. for 1 to 2 months, what are the HR and legal implications for the employee? This is a very common question and it's very complex. People make the assumption that it's okay to work abroad, to work from home if you're under an H-1B, but you have to remember, H-1Bs are very specific to an employer and are tied to a location. So you want to make sure that you're following the legal compliance, both with tax implications and immigration law if you're going to be working abroad for a few months. Make sure you speak to the immigration attorney that's handling the H-1 for your employer, so that you're able to follow all the guidance and comply with all of the requirements of your H-1B, because you also don't want to lose your H-1B because you're trying to work abroad, right? Now, in terms of tax implications as well, depending on the country where you're from, there could be some tax implications if you're working from home for a few months. Is it better to have good, strong points on 3 criteria than have okay to satisfactory points on 6? My personal opinion, and having done this type of visas for almost 10 years, is that it is better to have 3 strong criteria than having 6 or more that are not as strong. So I will say focus on 3 or 4, make the criteria very strong, because remember, it's also an overall analysis, right? So USCIS will make the determination if in the totality of the circumstances you meet the requirements to be extraordinary within your field. So make sure you do that. People sometimes think that they don't have enough evidence to make 3 criteria very strong, but the criteria of showing your original contribution to the field is my favorite criteria. You can really make an argument for that one. This one you can include patents. You can also, if you invented anything, a process that facilitated things in your industry, this is the category as well, where you will include the recommendation letters from experts in the field that are familiar with your work. Make sure those letters are diverse from different experts. They're independent, meaning that they don't work with you, they're not your direct supervisors, and they really talk about your work and your accomplishments and your impact in the industry, not you as a person. So that would be my recommendation. Okay, we answered this one already, so we're going to move on to the next one. Can one file an H-1B amendment and extension based on a minor salary annual increase more than 6 months before the H-1B renewal date to have an early renewal? So in terms of amendment, I will say this is a little risky approach, because even though it's the same role and the same requirements, it will likely go to a different officer, and officers have a lot of discretion. So when you are applying for an application, you are opening the door for a scrutiny, right? So you don't want to get an RFE or a denial on the amendment just because you're trying to get an earlier renewal date. And especially, the officers are very savvy when it comes to seeing when people are trying to think of strategies like this, right? Especially if it's a very small annual salary increase that's expected with your profession. That's not really a material change, so it is not really required to file an amendment, as long as you're being paid at the wage level or above. So I will say, speak to an attorney before you try to make this strategy, but it is not recommended, in my opinion. Okay, I am interested in applying for an EB-2 NIW application. What should I do before starting? I think a very good approach is to speak with a few immigration attorneys. Some of them don't even charge the consultation fee, but get an understanding about your credentials and where you stand right now in terms of accomplishments for work, and also where you need to do or why you need to do to solidify that portfolio. So as we know, one of the main requirements to apply for the NIW is that you have to meet the educational criteria or the equivalent, right? So if you have an advanced degree like a master or higher, then you're in a good position, and then you can start thinking about your work accomplishments. If you don't have a master's, but you have a bachelor's plus 5 years of progressive experience, you're also able to qualify under the education criteria. If, however, let's say you only have a bachelor's and 2 years of experience and you don't really have a master's, then you will need to meet the exceptional criteria, which is meeting 3 of the 6 criteria that USCIS provides. That one requires a little bit more work, and you really have to work on showing that you are exceptional within your field and that you have achieved several things, right? Now, if you meet the first part, then we'll look at how your work is of national interest for the US. So if you are in a good position, you have good valid non-immigrant status, you're thinking about the NIW, but you're not in a rush, you're thinking maybe in a year or two, it's a great approach to start thinking about the type of clients that you're going to be working on, right? What company are you working on? Is your company taking on clients that benefit the US, like government contractors, anything related to military or defense, or anything that's causing and creating an economic impact in the US? If you're able to have a say in the type of clients that your company is taking and putting you to work on, this will be a great strategy, right? So start thinking about that. But this is the overall steps, the overall requirement that I think you should think about before applying to the NIW. What will be a good time to go for the first time H-1B stamping next year, given all the uncertainties? H-1B renewal in September, given all the visa postponing. Okay, so as we know, as we saw on the news, with the new announcement of increased vetting for social media profiles for H-1B and H-4 holders, there were massive cancellations and postponements of visa appointments for people who were abroad waiting for their visas, especially for appointments for December, January, and this affected mainly Indian nationals because there is a huge population of Indian nationals that do have H-1Bs, so there is a higher demand. People were stuck abroad. They're seeing their appointments being pushed all the way until April, May, June, and even July. So in terms of a strategy, I will say the second half of next year looks a little bit better because all of the people that lost their appointments in December and January are taking the first half of the year. What's your rate for filing an EB-1A? I want to file in a week. Is it feasible, or do you advise that? For an EB-1A, I recommend that you take your time in terms of gathering the documentation, because I see situations, especially in social media, where people rush to file their EB-1 case and they get a request for evidence and they get a denial. So in the overall, it costs you way more time and more money than taking your time building a good strategy, speaking to an attorney. Also, keep in mind that usually this time of the year, officers, especially government officers, are taking vacation, so there are not as many officers adjudicating or reviewing these petitions. So you really are not really saving time if you file within a week, right? Like it's better to take at least 4 weeks to gather your information together, speak to an attorney, come up with a strategy to be able to file an application. We will provide a link for information where you can fill out our free quiz to see if you qualify for a free consult or if you can apply for a consult. And we can also are happy to provide you with information in terms of our rates. But now for your EB-1A, again, it is important to have a consultation, even if you don't hire a firm, because we do have very talented attorneys that have about 10 to 15 years of experience in average handling these type of applications. And we're very passionate about helping immigrant professionals achieve their dreams in the US. It's good to hear, take a look at your profile and hear where you stand in terms of filing the application. Good day. I'm currently on a J visa. Kindly advise if I can change status here. If your country is no longer on the skills list, DS 2019 is checked and subject to the 2-year. Okay. So the announcement that we saw, I believe it was last year or 2 years ago, where the Department of State removed a large number of countries from the 2-year requirement list. What this means is that people no longer are subject to the 2-year residency requirement just because they're born in that country. But that doesn't mean that if you were subject to the 2-year residency requirement specifically, and it might be listed on your J1 visa stamp, or if you got US government funding or funding from your government, that you are exempt just because your country was removed. Likely, you're still subject to the 2-year residency requirement, so you will need to get a waiver so that you're able to apply for adjustment of status here in the US without having to depart the US. Very important that you speak to an immigration attorney if you're thinking of filing an adjustment of status and a waiver, because if you file for an adjustment of status and if you're still subject to the 2-year residency requirement, your application will be denied. I am currently on F1 OPT expiring in February and considering changing to H4. If I later receive a PhD admission, can I change back to an F1? If you change to an F4, you can likely go to school, attend school with an H4. And if your spouse has an approved I-140, then you can get a work permit and you can work with any employer that you want, right? Like that's an independent work permit. Now, in terms of switching back to an F1, if you apply for a new F1 and you meet all the qualifications and requirements, you're likely to do that. Many people do this. They go from F1 to another status, and then when they get accepted into another university or another program, then they go back to an F1 status. How will the latest announcement on LinkedIn verification work for H-1B renewals? On what basis can the H-1B renewal be denied based on LinkedIn profile? So this is a very good question. We don't have a lot of guidance from the government in terms of what's deemed as high risk or controversial, and we have not received notifications from any clients whose application has been denied because of what they had on their social media profile. In terms of asking for LinkedIn profile, the government is just basically asking for your social media presence. So what we're advising clients is to look at all your social media, do an inventory, become familiar. But we're advising against people deleting everything, especially because we don't know what type of tools the government is using to track your presence. And it could be a red flag to the government if they see that out of nowhere, you're just deleting a bunch of content. So short answer, we don't have a lot of guidance on what the government deems as threatening the national security. We have not received reports of people who have been denied because of the social media vetting. What is a good time to start the H-1B application for 2026 draw? My recommendation, especially if you're interested in being considered for the H-1B, is start speaking to your manager as soon as possible. This is a mistake that a lot of foreign nationals make, and especially employers, is that they leave it until the end. Start talking now. Start thinking about hiring an attorney to handle the H-1B. Start thinking about the role that you will be including in the description. Now is a good time to start talking. Now, usually the lottery opens up in April, but they don't give a lot of time to register people. So it's important that you're ready to go as soon as they open the lottery for registration. Is the gold card a replacement for the EB-1 category in the future? How does it relate to the green card? It is not a replacement. As of now, we still will have the EB-1 and EB-2 category. What the government has announced is that people who are able to pay $1 million will likely be able to skip the part where you have to prove that you're extraordinary, right? Or that your work is of national interest. The $1 million will be the substitute for that part. Now, people under the Trump Gold Card are still subject to the visa lottery. If you are from a country that has a backlog like India or China, you will still need to wait in line for your priority date to become current for you to be able to apply for the permanent residency. I'm interested in pursuing an O1 visa. What are the eligibility requirements and what are the next steps? So we're going to provide a link with one of our blogs where we break down this information in a lot of detail. But the overall guidance on the O1, for the O1, you will need a petitioner. So it can either be an employer or it can be an agent, right? So if you want more flexibility in terms of what projects or what employers you can work for, it is usually recommended that you go for an agent. So the agent or the employer will own the petition. They will file Form I-129. If they pay premium processing, they'll likely get a response within 2 weeks. Once you have the approval, you can make an appointment at the U.S. Embassy or Consulate abroad. You don't have to, but if you want a visa to be able to travel in and out, make your appointment, go for the visa stamping, and now you're able to come in and out. Now, what is the eligibility requirements and what are the steps? Like I said, employer, petitioner, agent files for the I-129. If you're inside the U.S., they file it as a change of status. Once it gets approved, you are on the O1. If you are abroad, when they file it, then you will need to go to a U.S. Embassy or Consulate to activate the O1. The requirements is that you have to either have won an internationally recognized award like a Tony, Pulitzer, or Nobel Prize, or meet 3 out of the 6 criteria that they put forth in their website. The meeting that criteria is the most commonly one, right? Like the people use that one most commonly. But basically, you need to meet 3 criteria out of the 6. And within the criteria, some of them is that there is published work or publications about you, about your work, your contribution. Also, you will likely need 5 to 10 recommendation letters from industry experts. You need to show that you are at the top of your field. Perhaps you command a higher salary than those who are in the same job and in the same area as you. You have published. Publications are not a requirement, but if you have published publications, are people citing you? Have you done a patent? Basically, you need to show that you have provided original contributions to your field and that you have made an impact in your field. And when thinking about your field, try to be as narrow as possible. Another mistake I see for people who are applying for an O1 is that they go very broad. And when you're very broad, you have a lot more competition, right? So think about narrowing your area and think about an area that doesn't have a lot of competition. That's a great door for opportunity. Can those buying the gold card bypass the EB-1, EB-2 queue? If not, then what is the process after buying the gold card? Does it place one in front of the EB-1 queue? Okay, like I said before, the gold card is not substituting the EB-1 or EB-2 category. You still will be able you still will be subject to the visa bulletin. So you still have to wait until there is a visa available for you to be able to apply for the green card application. What the government has said is that buying the gold card, paying the $1 million, basically excuses you from having to prove that you either meet the EB-1 criteria or that you meet the EB-2 criteria. Is there any possibility that the H-1B wage-based draw going to happen in 2026 draw? We don't have any guidance or information on the government in terms of if they made a decision whether the wage level will create more opportunities for people to be put in the lottery more times. We're still waiting on that guidance. So stay tuned, because we usually put information as soon as we hear from the government. I heard many USCIS officers are judging EB-2 NIW cases with the EB-1 level of scrutiny, which is lowering the approval rates. How should applicants prepare a strong case under these tougher standards? So this is some of the feedback that some people have come back with. I haven't had a situation where this happened to one of my clients, so I wouldn't be able to speak from first-hand experience. But in terms of the NIW, as we know, the EB-1A criteria level standard is way higher than the NIW. For the NIW, I say really focus on what administration cares about, right? And then try to tie your argument around that. So this administration cares a lot about the economic impact in the US, being competitive with other countries, technology, and defense, right? National security. They really, really care about national security. So focus on that. Pay attention to the type of work that you're doing, how that correlates to national security. Are you working on a software that's improving computers, that's saving energy? Think about what is the military in the US using. They need computers that save energy longer when they go on missions. A lot of this information is publicly available, a lot of research, a lot of publications, so try to tie it back to that. I have a visa appointment in Mexico this month for an H-1B. There are no cancellations. What is your suggestion? This was booked back in August. So right now, in terms of going to an appointment, like I said, India saw a massive pushback of appointments because they do have a lot of people that rely on an H-1B compared to other countries, right? I would say continue monitoring the status in the U.S. Embassy or Consulate in Mexico. If you have a visa stamp that's still valid for a few more months, I'll say it's a little bit safer than, for example, if your visa stamp has already expired. My employer is helping me with the EB-2, but the recruitment process has not been successful. Can I switch to an EB-1 without my employer at this point? Yes. So EB-1 allows for self-sponsoring, which is great because you don't have to rely on testing the market with perm or on the employer. Unfortunately, there is a huge need for jobs right now in the US. As we've seen a lot of layoffs. So people are applying to jobs, and it is harder to make the argument that there are no US workers able and qualified to take on your job if we're seeing these massive layoffs. So even if your employer is supportive of you, I think with this environment, it is a great idea to start considering filing for a self-sponsored EB-1. How to justify critical work criteria for the EB-1A. This usually relates to someone having or holding a critical position at a reputable organization, right? So think about if you are thinking of applying for this type of visa, let's say in a few months or in a year, think about of being as involved as possible at work. Join a committee. Be part of a decision-making group in the company, right? The government wants to see that your work is either leading, right? Like you're either a manager or you're making decisions, or that your position is critical to the functioning of the organization. So again, make yourself as involved and indispensable as possible to be able to justify this criteria. What is the timeline for a national interest exception approval for a healthcare professional? I'm thinking this is probably for the national interest waiver. In terms of timeline, I think you're in a good position because of your profession. As we know, there is a huge shortage of healthcare professionals in the US. So if you can really make an argument on an area or a type of healthcare that you are providing, this will be a really good idea for you. In terms of the timeline, we also have published the processing times, so we'll try to look up the link and post it here. But if you pay for premium processing, you can get a decision. I believe for the NIWs is about 45 business days, rather than I believe right now it's up to 20 to 25 months. And when I tell people that they're able to look up the USCIS processing times online, you can just go to USCIS processing times. Then it will ask for you to select the type of a form that you apply for. In this term, it will be the I-140, and then the type of category, national interest waiver. If you see a huge number, don't get alarmed. Usually, what USCIS says is that they issue a decision on over 80% of the cases within this time frame. And they do this so that people are not constantly follow up, because you cannot follow up unless your case has fallen out of regular processing times. What is the current time frame for receiving a green card under the EB-1 category? It could take up to 2 years. I'm seeing up to 2 years. Again, depending if your priority date is current, depending if you pay for premium processing or regular processing, but it could vary depending on your situations, like 2 to 3 years. Over the last 6 months, have approvals increased or decreased for entrepreneurs applying under the EB-1A or the O1? So it looks like the information for the last month is not readily available. What we understand is that entrepreneurs are getting more savvy in terms of applying for this type of applications, because they know that the standard is tougher and the USCIS has raised the scrutiny. So this will likely lead to higher approvals. What do you think will be the outcome of the lawsuits filed against the H-1B, $100,000 fee, and when? We're closely monitoring this as well. We know that several organizations, nonprofits, and even private employers have filed lawsuits against the government, indicating that it is not legally permissible to just impose this fee. So we're monitoring the decisions, but we don't know how the courts are going to rule. They could issue a temporary injunction so that the government doesn't charge this type of fee, especially if employers are able to demonstrate that they will suffer an irreparable injury, which is likely to happen, right? If they're forced to pay $100,000, it's a lot of money, the injury is present. So let's keep monitoring, and we're going to keep informing everyone about the updates with the H-1B lawsuits. How does USCIS treat cases where applicants are missing payslips? I think it depends. If you're including payslips for, let's say, an H-1B extension, this will raise red flags, because pay stubs is a way to show that you have maintained your current valid status, that you have stayed with the same employer, and you're still working for the same employer. So it depends on the application, but for work visas, they're very important. What is the current timeline for receiving the physical green card after the EB-1 approval? It depends. So if you're referring to the I-140, then, like I said, the timeline from beginning to end could take up to 2 to 3 years. If you're already filed for the I-485 and it got approved, it could take a few weeks. So it depends on the type of application that you're waiting for. How can someone begin to build a strong profile for the EB-1A or the EB-1 to NIW in the biomedical or health informatics field? So for this type of application and field, you are in a good position because, like I said, there is a huge shortage of scientists and healthcare providers, and also research related to biomedical and health, right? For the EB-1, to build a strong profile, show that you're at the top of your field and that you have provided your industry with an impact and contribution. So the first thing is to narrow your area of expertise, because this is a little bit too broad, and then to really start providing evidence that you have made contributions. Have you done patents? Have you done research that now it's being used by hospitals? Have you done papers that now are being cited from all over the country, right? And this is why a Google Scholar profile is very important. So it all depends on that. Now for the NIW, think about how is your work of national interest for the US, right? Is there a shortage in the US or a critical need? If, let's say you're working on research on diabetes. What is that diabetes situation looking like in the US? What are other countries doing? So it's a different strategy, but you can reuse a lot of the information for both type of applications. What are the possible ways for accounting professionals to stay longer in the US except the H-1B? So accounting professionals, it depends on your path and your profile, right? But for an accounting professional, you can also look into being hired by a multinational company and maybe going abroad, let's say to the UK for a year, and then coming back into the US with an L-1B. That's a great approach that accounting professionals do. If you don't want to leave the country, I'll say start thinking about probably self-sponsoring, maybe through an EB-1 or an NIW, especially if your work relates to providing economic impact to the US. Have you seen any cases where such beneficiaries outside of the US and with a valid visa stamp had a smooth change of employer petition approved? Okay, so this refers to people who are outside of the country with a valid H-1B visa. So if you have a valid visa stamp and the employer is just filing for a change of employer, you'll likely be in a good position, but it depends if USCIS sends the petition for consular notification, then the fee might likely approve. But for someone that has a visa stamp, and files a very strong petition, they really shouldn't have a problem in terms of being successful. What is the risk associated with finding concurrent H-1Bs? One part-time with a cap exempt employer and one full-time with a cap subject employer. So I think this depends. Were you subject to the lottery and you get a separate H-1B, or as most people don't know, if you are under a cap exempt, you are also able to concurrently file for an H-1B that's subject to the cap without having to actually go into the lottery, but you will need to keep the employment with the cap exempt employer. So this is a question that requires a lot of detailed analysis in learning about how many hours you're working. So please feel free to schedule a consultation to speak to one of our attorneys. But overall, the risks, if you're able to qualify, are not that high in terms of having a concurrent application. People do it all the time. We answered this question already, so we're going to move forward. So for the J1, again, these type of visas are very complex and need a deeper analysis. But if people that had J1s and lost them because, let's say, they lost their job, are able to successfully apply for new J1s as long as you meet all the requirements and criteria. Added clarification, have you seen any cases where such beneficiaries outside of the US had a smooth change of employer petition approved without the $100,000 fee? I haven't seen many of these, not because they're getting denied or the $100,000 fee is getting applied, but more because employers and employees are being very conservative. they're not traveling outside the US. They're filing their change of employers here in the US, and they're staying here until the H-1B is approved. What are the current processing times for common visa categories? If I apply for a new visa and my current work permit expires before the new petition is approved, can I stay in the US working? Also, aside from the F1, what other type of visa someone can use to study? So in terms of what other visas you can use to study, you have the J1. Also, if you're on a dependent visa like an L2 or an H4, you're likely able to study. Now, the processing times for visa categories, again, you can go online at USCIS processing times, select the type of form, either I-129 for all of these work visas, and then narrow the category to H-1B or O1, and then see how long USCIS is taking. But let's say you file an extension prior to your expiration and you still don't get a decision by the time your current visa expires, then you're likely able to rely on the 240-day rule, which allows you to continue working and living in the US for up to 240 days, or until USCIS issue a decision, or until you max out, depending whichever is shorter, as long as you don't depart the US and you stay grounded until you see that approval. Okay, we have a few more minutes, so let's try to take a few more questions, maybe 2 or 3. Okay, we spoke about this one already. Another question, I've seen people currently outside of the US, but with a valid H-1B visa getting RFEs post the 15 days premium processing timelines. Wonder why this is happening. Well, USCIS is legally required to stop the clock when they issue a request for evidence. And if premium processing was paid and accepted, they're supposed to issue a decision within 15 business days. So I think people, because before it used to be calendar days, right? So Saturdays counted and also some holidays, but now it's business days. So some people get confused and think that the old standard applies. It's business days. Weekends and holidays do not count. So make sure you do the math well to ensure that you're not counting days that are not supposed to be counting towards the 15 days. So for this one needs a little bit of a deeper analysis, especially with the type of work that you're doing. But please feel free to schedule a consultation, and one of our attorneys can provide you a more tailored feedback. Compensation above $230K last 2 years. Can I justify high salary? For the high salary criteria for the EB-1, it totally depends on your job, your title, and the area of employment. So my recommendation will be go to the Department of Labor website, search the employment handbook, see what they're recommending for professionals with your credentials, your job, and in your area, how much they're making, right? Because $230K for, let's say, a developer in a state in the north, where in a very, very small city, could really qualify for this criteria. But $230K for a senior software engineer in San Francisco might not be of a stronger argument as the other one. So be mindful of that. Compare your salary to professionals within your area, and then you'll likely get a response. So for this one, which membership satisfy EB-1A criteria? IEE senior membership, or fellow. So for the membership criteria, it's probably the membership. And keep in mind that to satisfy the membership criteria, you actually need to apply, right? Like you can't just be part of it because you hold a degree or you pay a fee. You have to apply, it has to be competitive. Now for a fellowship is a very interesting one because it could also qualify, but you can meet 2 criteria. You can include it in the membership criteria, and you can also include it in the awards criteria, because it's a fellowship is an award. You're applying, you're competing against other people, you're being awarded either the fellowship or the money or the scholarship because you are above everyone else in terms of your achievements. How do I decide between the EB-1A and EB-2 NIW based on my profile? This depends on how, let's say, how public your work is, right? So if you have gotten a lot of recognition, if you've been on publications, if people are talking about your work, if you've been on podcasts, even if you're doing a work that's not of national interest, like for example, a makeup artist could get an EB-1A, right? That's not of national interest. But if they're putting makeup on people that are going to the Met Gala or to the Oscars or working with celebrities, they could qualify for an EB-1, right? Now, think in terms of EB-2. For EB-2, the requirement is a little lower in terms of how publicly known you have to be, but it's more about how your work is of national interest for the US, right? So, for example, you could have no publications and no social media presence, but if you're working on a software that's directly being used by the US military, that would work, right? So think about EB-1A, public recognition, higher standard, but higher approvals. EB-2 NIW, lower approval rates, but the standard is lower, and your work has to be of national interest. What options do I have if I'm not selected for the H-1 lottery? You could do the H-1B lottery parallel to something else. Like, you don't have to wait until you don't get selected. Like, you can start right now working on building your profile for possibly creating a path for an O1 or an EB-1 self-sponsor, while at the same time having your prospective employer put your name in the lottery. What are the most common reasons EB-2 NIW cases get denied? This is a great question. Actually, I worked on a huge project about a year or 2 years ago where we had an employer that fired their law firm and came to us to fix the mess. And we had to go over a bunch of denials and then refile the applications. And this was a great insight for me because I was able to see what USCIS is thinking about when it comes to denying. And one common mistake that I kept seeing repeating, and this was a very large, reputable employer, very sophisticated, is that employees focus on their contributions to their job and employer, not really to the US national interest, right? They had great backgrounds, great credentials, great education, but they were talking about how their employer was great, how their employer was at the forefront of research. They were not focusing on their accomplishments. They were focusing on the employer. Another mistake that I saw is that people were including recommendation letters from direct managers or even people at a very high level at the company. They don't get as much credibility as getting an expert in the field who has not worked with you, but is familiar with you and your work. So that's another mistake that I saw when people got denied, but mainly not being able to show that your work is of national interest to the US as a whole, rather than the employer. Can someone apply for multiple green card categories at the same time? For the I-140, yes. Like, you can have a perm running parallel to, let's say, an EB-1 I-140. But when it comes to applying for Form I-485, which is the actual green card application, you're only permitted to have one. Okay, I think we are done with the questions. Thank you so much, everyone, for joining. And we're going to be doing more of this more often, especially with all the breaking news that are happening. If you want to comment on the videos or send us more specific information or any ideas of videos that you want us to make, we welcome that as well.